Probate, trust, and quiet title. Shelter is one of the most important things that humans need to survive, to have a stable family, and the purpose of mental health. Shelter is being stripped away from many people. The reason why is not because the people that's doing the stripping away of the essential thing that humans need to survive. It's not that they're right or perfect. It's that most people are unaware of the tools they need. We've been speaking about why it's very important and how you can put it to use when it comes to a circumstance where someone is clouding the title through mortgage private contracts. Call that promissory note. It's the promissory note, and then the mortgage itself is a term and condition that is saying that that shelter of yours will be used as a collateral. Find that when it comes to situs, some of the situs is actually in probate court. The question is, why are some situs located in probate court? That's because probate is the medium that they use to escheat your property, subrogate to take your stuff. Usually probate is an equitable jurisdiction, and when you put your trust as a situs into probate, it puts them on notice. It's through the use of a trust. In order for probate is the judicial process whereby a will is proved in a court of law and accepted as valid public document. That is the true last testament of the deceased, or whereby the estate is settled according to law of intestacy and the state of residence at a time of death and absence of legal will. In other words, probate interest in property. That interest in property could be a vehicle. It doesn't always have to be property. Real property is land and the things attached to it, like a house. Estate, proper in form, literally, it could be in form of cloud documents. Literally, it could be some gigabytes and terabytes of information. Whenever all that called estate goes into probate, what they're saying is it has been the process to which the instrument that says all this estate is to go to someone or to be handled this way. That paperwork that instructs people to handle it a specific way, or if it doesn't exist, then who is to go to. What probate is, the one who proves it is called a surrogate or an acting judge within the probate department of whatever venue you're located. And guess what? They do it through something called, it went over on YouTube. Probate is the judicial process whereby a will of some is that you're triggering. When you don't have 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 your private contracts in place, then someone is going to have to step or two on relationship to 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 the people of the state of so and so versus you. Whenever probate and estate matters are brought into court, look at it. There's a video we did regarding the different types of trust, and we broke down the fact that a will is separate from a trust. Yet a will is an instrument that can be placed into a trust as part of a trust instrument. Probate court decides the legal validity of a testator, deceased person's will. Why would you want them to do this? Also known as granting, acting judge itself becomes the grantor. You don't want that. When someone grants something, they are playing the role of a grantor, the role of trust relationship. You see what's going on? They play the role of a grantor to the executor. Executor is supposed to be the one to will designate as the party that does something. So the existence of a will is not sufficient to avoid probate. Your existence of a will, the grantor. A will is an incomplete aspect of what a trust is supposed to be in many videos, more specifically on YouTube. You want to avoid probate. Constructive trust is just a type of trust under the presumption that you're doing something wrong, so now they have to step in and play God. That's the same thing that's going on in probate many videos, more specifically on YouTube. You want to avoid probate. Constructive trust is just a type of trust under the presumption that you're doing something wrong, so now they have to step in and play God. That's the same thing that's going on in probate. So create trust. Listen to this. The probated will, and it becomes the legal instrument that may be enforced by the executor, meaning it's a probability upon it being proved, may be contested from the executor. If you say you're the executor through court test and control test, they cannot touch them. But why do you not want to be an executor or an executrix? The executor also has to pay off any taxes and debt owed by the deceased from the estate. Meaning the only thing you're inheriting will of someone who's dead, called a testator, is liabilities and issues and problems. to which other people can come in and whip you to the side and take your things. Creditors usually have a limited amount of time, approximately 1 year, meaning a statute of limitation for have a limited amount of time, approximately 1 year, meaning a statute of limitation for have a limited amount of time, approximately 1 year, meaning a statute of limitation for anyone who wants to make a claim against the will from the date of the death to make any claim against the estate for money owed to them. Claims that are rejected by the executive. Entire 26-minute videos on the Patreon page. Take care. Best of luck.